Hindsight Radio, the place for right knowledge.
Peace, everybody. This is Akeem from Hindsight Radio, the information station changing the nation. As you may know, or if you don't know, I'm the host of the Truth Tuesday show on Hindsight Radio every Tuesday. If you want to hear that show, go to blogtalkradio.com/Hindsight 2020. It is live every Tuesday, 7 p.m. Eastern Time. We also have another show called The Divine Connection Show. Jessica and Tasia host that show now on Thursday, 7 p.m. Eastern Time. Same place, Blog Talk Radio /Hindsight 2020. All right, what is this video about? Express trust, as you can see on the screen. Why am I doing this? Is because, like always in this movement, people want to teach you stuff and give you the illusion that it's something special, that you can do something special, namely, for the sake of this conversation or this video, discharge. And I'm here to clear a couple of things up so you know exactly what an express trust does and how special it is or not special it is. Just simply here to give you the truth of the matter. Okay? In general, people do love to give you special terms that you may not be familiar with that are just terms, just so you can understand what it is. So, let's see. I had something up. Here it is. What is an express trust? An express trust is simply a trust that is created on purpose and not imposed by a court. So anything could be an express trust, you know, and it could be either a verbal express trust or a written express trust. Okay? So, if, a verbal express trust, I can hand somebody my keys. Hey, you have my keys, you can come to my house. Here's the keys to the house. Boom, here's the verbal express trust. And then I give you terms of that trust as opposed to implied, where if I just give you the keys and I don't give you no rules to the game, then that means you're going to imply that you can come and go whenever you feel like it. But if I want to set parameters around that trust of giving my keys, I will tell you exactly when you can come here, when you can't, and what you can do when you get here. I give you explicit terms. That's why the law has to put it in writing. For a trust to be determined as an express trust, these are the rules to the game. So we can look at it as an express trust and not as an implied trust. You see what I'm saying? So let's look at right here, Georgia Code. Here it is. An express trust shall be created or declared in writing and signed by the settlor or agent for the settlor acting under a power of attorney containing express authorization. Now, A is a very powerful statement if you've been listening to my station, my station or my show. It says, I'm going to read it again. An express trust shall be created or declared in writing. So, you got to create it and declare it in writing and signed by the settlor or agent for the settlor acting under a power of attorney containing express authorization. So it must be declared in writing, signed by a settlor or an agent for the settlor acting under power of attorney containing express authorization. If you went to my last seminar, I spoke about power of attorneys and how important they are. But that's for another video, or mainly the details will be in my private membership. Those who are part of that will be learning about that in a week or so. B, an express trust shall have ascertainable with reasonable certainty, 1, an intention by a settlor to create such trust, 2, trust property, 3, accept for charitable trust a beneficiary who is reasonably ascertainable to the time of the creation of such trust or reasonably ascertainable within the period of the rule against perpetuities. 4, a trustee, and 5, trustee duties specified in writing or provided by law. So the trustee duties must be expressed as well in detail. C, the requirement that a trust have a reasonably ascertainable beneficiary shall be satisfied if under the trust instrument the trustee or some other person has the power to select the beneficiaries based on a standard or in discretion of the trustee or other person. So, an express trust must have all of these things according to the Georgia Code. I'm going to go to North Carolina codes and read their rules as well. Whenever you're looking up anything, you must look at different states and see how they're determining and what they want. You must study your state. Now, there you go. Does the trust need to say if I want to create a trust and I say Akeem L. Express Trust. Do I need to put Express Trust in there? No, I do not. All I have to do is say Akeem L. Family Trust, Akeem L. Religious Trust, Akeem L. Whatever Trust, or Akeem L. Trust. It doesn't have to say Express in it. But for the Georgia to see it as an Express Trust, I just got to follow these rules. 1, intention by the seller to create such a trust. Trust property. A trustee with specified duties. There it is. That's all it has to have. That's an express trust is just a guideline or for them to recognize it as not being just an implied trust. For us to see it as an express trust, this is what the rules say. Because if you don't have express terms, guess what happens? It becomes implied, and then it becomes under the jurisdiction of the court to figure out what the trust is. Most people die without wills. So guess what happens? They go to probate, and guess what? The law decides what happens to that person's property, or individual or natural person's property. They decide. This is why you have to have an express trust. So, let's go to North Carolina's code. Scope. The chapter applies to any express trust, private and charitable. Let me make this a little bigger. Private and charitable with addition to the trust wherever and however created. The term express trust includes both testamentary and inter vivos trust. What is a testamentary trust? A will. A will is a trust. A testamentary trust is a trust a will that is created and expresses what happens to the estate or the person's property after they die. An inter vivos trust is a living trust. What you want to happen to property while you're living. So if I set up a trust for my children, which will be, and while I'm still alive, that's an inter vivos trust. And I'm giving orders to the trustee to do certain things for the beneficiaries. Basically what it's saying. All right. The chapter also applies to any trust created for or determined by judgment or decree under which the trust is to be administered in the manner of an express trust. There you go. And you keep reading these. I would read all of these rules. And also custodial arrangements under 33A and 33B. All right. If you don't, 33 is a very significant number, so read that. All right. I won't go into details why I'm telling you to read that. All right. There it is. There's an express trust. Now, the reason why a lot of these individuals are telling you about express trust is because of this Weiss's concise trustee handbook, and that's all it talks about is express trust. So I can see how a person can get confused and say, well, I need to say Akeem L. Express Trust in there to make it work. No, you don't. Now here, what I like about this, it tells you creating a trust by act of a party. Implied, express, it can be oral or written. Oral trust is, I give you my keys to my home. And I just hand it to you. Here's the keys. Boom. These are the things you can do with those keys. I just express my intentions to the trustee of those keys. Written, I write it down. Boom, boom, boom. We are in trust all the time. When you go to a bank and you give them their money, they give you an express trust because they have complete terms of that agreement, your banking arrangements with them. Because most of the time it's in their favor. So whereas you're creating your own trust and you're expressing terms in your favor. So, I mean, this is a good read, but a lot of people are reading this and using this as a tool to say you can discharge and do things like that. Just, listen, basically it's a money-making scheme. That's all it is. People are creating trust all the time for the purposes of protecting property, protecting themselves. Is there a way to discharge? I wouldn't even call it discharge. I would set up a trust simply to remove myself from the straw man, conduct commercial business. That means buying, selling credit, creating credit for that trust, and then creating 1099s, whoever I did business with, at the end of the year, and then file my 1041 tax return for that trust so that I can get the appropriate deductions and credits for everything I do business with. Now, some people call that discharge. In a way it is. But when I break this down to my private membership for the people that are already involved, that private membership right now is closed. I got too many people. I have not too many, but I have enough people already. I will reopen it sometime in the future. I've already got my people who are in it. So I know you're going to listen to this video. How do I get involved? You can't right now. I'll be sending out an email list. So if you want to be involved in my private membership, where I'm going to teach you how to execute your trust and your estate properly, so that you can do your 1041s properly, go to akimel.com, get on my email list. This way you can see everything happening with Hindsight Radio. All right? So an express trust simply is a trust that is got detailed information on what the trust is doing and what the trustee's duties are. Now, another thing that confuses people is this. Do I need to register my trust? Okay. Let's find registering the trust. Do you need to record your trust? Boom. Simple. This is what I do. I do it all the time. It's right there at the top. It is not necessary to record a trust. However, if you want to record your trust, you may do so at your county recorder or clerk's office. It's not necessary. Why? Because it's a private contract. Aren't we talking public versus private here? Simply. You don't have to record it, but I read something in the beginning that needs to be recorded. And I'm going to go back to it. I'm only going to touch on it right here. Right at the very top of this thing, it says, an express trust shall be created or declared in writing and signed by the settlor or an agent for the settlor under a power of attorney containing express authorization. Now, when you understanding what straw man relationship or in legis relationship is, and for all those who don't know what in legis is, let me just type it in so y'all can understand what I just said. In ins legis. What is an ins legis? Latin. A creature of law, an artificial being as contrasted with a natural person. Applied to corporations, considering as deriving their existence entirely from law. That's in legis. But a trust is a person too. So if I create an in legis trust, like a Kimel trust, that's an in legis person. Now, one of the things that I like to also go over in regards to recording the trust is this. This is why recording your trust is dangerous. Always look at definitions of things so you'll know how they're determining things. And one of the things, a person, let's look at number 12, a person, an individual, corporation, business trust, estate trust, partnership, limited liability company, association, joint venture, government, governmental subdivision, agency, or instrumentality, public corporation, or any other legal or commercial entity. So, a person is all of these things. So, the state is a person, because it said governmental subdivision agencies, government. They're all person. The reason why you guys are getting in trouble because you coming in as that illegalist person, which has no rights at all. The one they created, the slave illegalist, and you're using it. No, you can't come against the government with that. You got to come up with something on level with them that they recognize and do business with all the time, which is trust. Corporations. All right? That has its powers. Corporation soul. I'm just being general here, but keep going. Let's go down to some more definitions. In this one, in North Carolina, they do not. Okay, state number 19. This is why you have to read the instructions. A state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, or any territory, insular possession subject to the jurisdiction of the United States. The term includes an Indian tribe or band recognized by federal law or formally acknowledged by a state. Now, according to this law, and you'll see this in every definition pretty much in every state of the union, saying that specifically, they're letting you know this trust code is under United States jurisdiction. Federal is a federal territory. So if I record my trust in a federal territory, what happens to that trust? It becomes a U.S. person. That's why I read person first. So when you're being told, oh, record it, you got to do this and you got to do that. No, you don't. But you do need to do this. An agent for the seller acting under power of attorney containing express authorization. Okay, so you need power of attorney to have express authorization to start doing business on behalf of that illegal state created. See, they got a power of attorney. Just to bring my point home, and I'm going to end it here, when you go to an attorney, the first thing he has you fill out is a power of attorney. Aren't you, when you fill out a check says authorized agent, when you sign it? What is it saying? Agent for the seller acting under power of attorney containing express authorization. And I'm going to leave it there because I know y'all got some more questions. What is he talking about? I got your curiosity piqued on that one. See, this is what these gurus are not paying attention to. I pay attention to details. And I look at everything because everything in the code means something, not just express trust. Yes, you need an express trust to conduct your business properly, but what type of express trust? Me personally, it would be a religious one because the Constitution protects my religious freedom. So when I start doing business, I'm protected. And with I feel spirit taking over for me to keep going, and into corporate soul and how that plays into this whole thing. But I'm gonna stop right there. There you go, express trust. That's what it is. It's a simple term, just to let you know that in order for your trust not to be treated as an implied or a trust that is just implied and the law should take over it and determine what it means, you have to express the meaning of the trust. Give it definitive terms. That's it. That's all it means. Okay? All right. Thanks for listening. Once again, I appreciate all of you guys' support of Hindsight Radio over the years. And as a show of appreciation, I will keep bringing you these truths so that you can get remedy for yourself and your families. By the way, look at the press conference about those public figures who sold off the stocks right when they heard about this pandemic. And one of them said this: I don't know anything about any stocks being sold because my trust handled that. Wow. Now, how did they know he sold off these stocks? Because maybe his trust was named in such a way, hint, hint, that it looked a lot like his Illegas. And with that being said, peace, prosperity, wealth to all. Keep your head up, stay positive. Don't be looking at all this crazy news. They're going to do what they're going to do. And peace.